We've been talking about the legal, ethical, and creative side of the use of AI inside of the publishing industry, but can publishers use artificial intelligence to summarize a novel that they have contracted or to blurb that novel that they have contracted? Let's talk to everybody's favorite IP and entertainment lawyer, Tony, to find out more.
My name is Tony Iliakostas. I'm an adjunct professor of entertainment law and IP at New York Law School, and I have an Instagram, YouTube, and TikTok account called The IP Professor that's dedicated to all things intellectual property.
We've had an interesting conversation come up about using AI to summarize or to blurb books in the hands of the publisher. So we're going to talk about two parts to this, Tony. The part where they're using this for advertising purposes and the part where they may be using this inside of queries. So if a publisher is going to use AI to summarize an entire novel for the blurb on the back of the book or the blurb going on Amazon or Barnes & Noble, is that something they can legally do?
So that's going to depend on essentially the format of the contract, the publishing agreement between the author and the publisher. Remember that at the end of the day, yes, the author is providing a work of authorship, and the publisher is then taking that work and mass producing it to audiences, right? To send to bookstores for people to purchase online, in physical bookstores, what have you. But at the same time, as much as the author is giving something, there also has to be a reciprocation of that service or some type of reciprocation in order for there to be a full-fledged essence of a contract. And in this case, the publisher is obviously not only just mass producing it, but they're helping with the marketing of the book. Usually in a publishing agreement, it's going to lay out what specific obligations or how the publisher will engage in the marketing of the book. And given the proliferation of generative AI, and surely given the legal complexity of AI, and I'm talking specifically about the DC District Court case that went down last summer about anything generative AI not being worthy of copyright protection. I'm talking about the pending open AI lawsuits that are easily going to definitely shake up the landscape of copyright law as we know it. All of those lend to this discussion about obviously the generative AI world being the wild, wild west. And I'm sure that a lot of people are very apprehensive of the use of AI related to their work of authorship, where they authentically created something with blood, sweat, and tears, with a lot of effort, a lot of time, probably a lot of money that was probably invested in something like that. So if a publisher is going to use AI, I would suspect that at the bare minimum, the publishing agreement would make some type of disclosure that the publisher is going to employ the use of generative AI for the creation of a synopsis for the back cover of a book, or maybe to provide a synopsis that they can provide to bookstores when they want to upload, let's say an image of the book and a little synopsis to begin the process of pre-orders of said book or said publication. Even there's a world where that same generative AI blurb that's generated using artificial intelligence could even be used as, like, let's say, the small tagline under a poster that maybe you see in subways, on bus billboards, even on a billboard in the street. I mean, there are umpteen ways that generative AI blurb could be used, but you can't just recklessly use. Now, I don't want to say recklessly, it's a little too aggressive, but I will say you don't want to just go ahead and do it without at least giving some type of notice to the author that that's the plan. Also, you have to remember that generative AI platforms like OpenAI, ChatGPT specifically, are very much in the spotlight right now and under harsh criticism, because the question is, or the thought that's happening, or at least what we're seeing in real time, is that engineers are using platforms like ChatGPT, constantly advancing it, but they're doing so with ingesting of data to make that platform better. And how do you ingest the data? You literally take, let's say, PDFs and you put it in the server. You take digital files of the books and you put it in the server. You find resources on the internet and you put it in the server. And somehow this AI churns up all this information, and then it could regurgitate it and spit it back out in some form. Whether it's efficient or not, it's up to, the jury's still out on that. But either way, that's how it usually gets done. Now, the question that maybe an author would have when they're working with a publisher is, are you using like a very specific generative AI platform? Are you using something like OpenAI where, privacy considerations are a little bit, flaky there?
Mhm.
Or is, let's say, a publisher like HarperCollins or Random House or Scholastic, are they using, let's say, proprietary software, generative AI software that they created to help create a synopsis? If it's the latter, that's a safer bet. That's much more kosher because at least it's a proprietary product that's not going out there into the ether, into the world wide web. But with OpenAI, it's the wild, wild west for sure. So all that to say, this is the kind of thing that I think all authors should be very, very proactive on when they're reviewing publishing agreements today. They should definitely make sure that there is some type of provision included in their agreement that allows the lawful use of generative artificial intelligence with the author's consent. Don't do anything without your consent. At the end of the day, this is your book on the line. You want to make sure that you have at least some type of say in the process. If your contracts are presently silent on it, I would go to the publisher. I would just be transparent and I would say, hey, what's the deal? Are you going to be using generative AI to help create a blurb? Go to your publishing lawyer, ask for their help as well, because they may be able to sway the decision or at least get the publisher to be very candid and honest about it. But bottom line is you have rights, you are a creator, and I think the least you can do is certainly ask questions and make sure that your rights are being protected in some manner. And hey, I think the way generative AI is right now, you don't want to play games. So I think it's a safer bet to just ask those questions, those hard questions. And listen, once you ask those questions and you get the answer that you want, at least you can sit back and say that you figured it out and it was done in an amicable fashion. Obviously, if it escalates to something a little bit bigger, then we're having a totally different conversation.
And I think that's really important to lean into because it depends on what type of generative AI components they are using in this. Sometimes it can be out in the open. Sometimes inputting your content can be a problem because it's training that AI if it's not proprietary things that they have created. So on that note, Tony, I want to switch gears just a little bit and talk about the querying side of things, because when this conversation came up, my first thought was that publishers are not necessarily using it to blurb the books for sale. They're using it when they're getting queries in. They'll read that first chapter that was sent in. If they decide they want to see more of the book, they'll then request the manuscript, put it through an AI, and get that 1 or 2 page summary out to see if it hits the points that they want in order to decide if they're going to read through the entire rest of that query. With that in mind, as authors, as writers who are sending things in to query, do we need to be mindful of this? Is there anything that we need to put in our emails to protect ourselves from this? Is it something we should be worried about that they're going to then take our manuscript and put it in some sort of AI without our permissions? Can you speak to that?
Yeah, this is actually quite tricky, and I'll kind of bring up something that's not in the realm of books, but somewhat of a similar tangent. So in the Hollywood industry, if you have an idea for, let's say, a TV show or a film, and let's say that you haven't really formulated a whole screenplay, but you want to pitch the idea of, let's say, a pilot or a film idea to a studio or a production company, oftentimes prospective screenplay writers or writers of a script, whatever, they will submit what is called a screen treatment. And the screen treatment essentially is their own synopsis of what the show is going to be about, what the film is going to be about. And, it's very, very minimal. Now, there are some authors that will do what are called, I think they're called script treatments. It's like a hybrid of a screen treatment and a script, where they'll have a whole blurb about a synopsis, followed by maybe some dialogue to help set the narrative of what the script would be like, followed by another blurb that's a continuation of the screen treatment, so on and so forth. Actually, a very good example of that is the very early manuscript that George Lucas wrote of the Star Wars. That's what it was called. And in that screen treatment, it's basically flips between blurb about, setting the stage of what the scene was going to be with some dialogue and so on and so forth. So we've seen it time and time again. But that said, the question that has often come up with screen treatments are, what happens once you share that information? It is now that the intellectual property of the production company? Is that the intellectual property of the studio? And this is where it gets very tricky. Oftentimes, if you're, let's say, working off of a form from a production company or from a studio, they may contain those disclaimers that say that if you share this idea for a film or television show, they may not accept your version of the story, but it is at their discretion to decide to take the storyline and develop something fresh out of what you've submitted. So you're beholden, unfortunately, to the power of the production company or the studio. In the context of publishing, I would be very, very, very hesitant if something similar to what we see in the screen treatment world in Hollywood is something that happens in the publishing industry. When you pitch an idea for a book, or when you pitch a manuscript and you're providing a sample to a publisher like Random House or HarperCollins or Scholastic or Penguin or any of these other massive publishers out there, you want to be careful. You want to make sure that it's properly disclosed that this is your intellectual property, that in no way, shape, and form are you providing or creating some type of exclusive relationship between you and the publisher unless they end up agreeing to publish your manuscript. You want to register your copyright in the U.S. Copyright Office even before you're having this discussion. Basically, you want to take any and every precaution to make sure that your rights are automatically protected with whatever you're providing, so that in the event that publisher X decides to take your manuscript, go onto a generative AI platform, generate something out of your work without your knowledge, and then they say, no, thanks, we're not going to use it, but then they end up making a book that's awfully similar to it, at least you have a paper trail. To quote Real Housewives of Salt Lake City, sorry, I'm going to binge her on that one. Heather Gay says receipts, proof, timelines, screenshots, all of that. I'm not even kidding you. Iconic line, especially in the legal industry. You want to keep those receipts, proof, timeline, screenshots, any and all proof that shows that you exercised due diligence and that your rights were abused by another publisher will get you at least an inquiry on a copyright infringement claim that will allow you to begin that process of filing a lawsuit, whether that's by way of the Copyright Claims Board, which is the small claims court version of things in the U.S. Copyright Office, or a full-blown lawsuit in federal court under, the U.S. Copyright Act of 1976. So you have options. Obviously, again, I would highly advocate speaking to a publishing lawyer if you're in that process of, submitting a manuscript to a publisher and you're very apprehensive about them potentially using generative AI to decide how they're going to review your manuscript and decide if you're going to be picked to have your book published. I think having any and all precautions and working with someone that will advocate for you is the name of the game on that front.
And do you feel like adding a disclosure to that email when sending in that query saying not to use generative AI or assistive AI to go through and recreate that summary for them is a wise choice, or is that something we definitely need to be speaking to a lawyer for to get the specifics on?
So I would say talking to a lawyer for the proper disclosure is definitely going to be helpful because every fact pattern is different. But I will say this, by way of creating a clause like that, you're essentially creating, it's almost like a dig back at the publishers, because publishers are kind of known to be unilateral in a lot of ways. Like, you agree to this and you can't change it. You're stuck with it. Yeah. You're almost providing that same scenario. It's like a touche move. You're basically saying, I'm unilaterally telling you that you cannot use generative AI. Publishers could totally blow you off and say, you don't know what the heck you're talking about. I'm still going to use it anyway. So bottom line is, I would say even before you submit the manuscript to a publisher, I think working with a publishing lawyer to contact the publisher to kind of work out the kinks early on would probably be the best move. Maybe there has to be some type of mutually agreed upon contract or understanding via email, whatever, that lays out that contingent on the provision of a manuscript, publisher X won't use generative AI to query to query what the synopsis is, what the crux of the book is. I mean, I think you're essentially creating some type of exchange there of consideration. It seems to make sense. I think that's something that would have to be negotiated, though. My hunch kind of tells me that unilaterally making that move is just not going to cut it. knowing the power of these publishers, I would be shocked if they were like, "Oh yeah, we'll definitely abide by those terms." I know these publishers better than anyone else, and I think I think they're not going to apply for that.
And it's important to point out that they get hundreds upon hundreds upon hundreds of queries, and if you do something that they don't like, they have things that they can do other than hang out with you. So be mindful of that.
That's right.
You got to take that into consideration as you're doing your query. But we've got lots of videos on querying, on working with the traditional publishing space in our playlist here on the channel. So make sure you're checking those out as well. And if you have follow-up questions on this or anything related to the legal side of the publishing industry, now's the time to drop those questions because Tony's coming back for more episodes. And as always, you can reach out to Tony on his social media. Tony, where can everybody find you?
You can find me on Instagram, YouTube, and TikTok at the IP Professor. You can check out my entertainment law podcast called End Scene, with new episodes dropping every Friday on Apple Podcasts, Spotify, or wherever you listen to podcasts.
Drop your questions down below and make sure you go through the AI and publishing playlist. We have so many episodes on the legal, ethical, and creative side of AI use in publishing so that you can use this to your benefit without crossing lines and causing problems or potentially hurting the copyright of your book. So now's the time to let us know what you're still concerned with, what your worries are, what you are thinking of using this for, so we can make sure we're doing this the legal, ethical, and creative way inside of this industry. And we're dropping daily videos helping you navigate the world of publishing, from your writing to your publishing to your marketing, to make this your most profitable year ever with the least amount of stress and overwhelm and time commitment for your content creation. We'll see you in the upcoming episodes.